Before we jump straight into the video, a small announcement. Lawfren Elite 2027 badge is out now. This badge prepares you for 8 3-year LLB entrance examinations across the nation, and it has around 115 plus full length mock tests and a countless number of sectional mocks. You will get proctorized all India mock tests, you will get detailed audio video review on your NLSAT Part B solutions, you will get monthly current affairs compendiums, you will get dedicated NLSAT Part A and B handbooks with solved PYQs. So, what are you waiting for? Contact us immediately or visit our website www.lawfren.com for more such details, for more such experiences. And this YouTube channel already has documented the experiences, the journeys of a lot of previous year toppers. Do refer to them as well. And as we always say, keep learning, always aim to grow, and always aim to be.
Everyone, welcome back to Lawfren Elite 2027. This is lecture number 4 in our Part B legal answer writing series. In this lecture, we'll be talking about understanding the major types of legal reasoning questions. Before we begin with this lecture, a small heads up, a few housekeeping rules. This lecture will be going on our YouTube channel as one of the demo videos. So during the course of the lecture, if you have any doubts, please raise your hand. Do not write anything in the chat box because I believe that may get recorded on the screen. With respect to that, we will nonetheless be having our doubt clearing sessions at the end of the class, and that won't be recorded. So feel free to ask your and feel free to keep your doubts for that part of the session. And with that said, let us start the session right now. Our copy checking will be after the lecture as well. So we'll be taking up the last class questions, see all of your answers, we'll be evaluating them in the end of the lecture as well. So right now, for the time being, for the first initial 30-40 minutes of the lecture, let us keep it a completely discussion based, engaging based or substantive thing, wherein we go through all the different kinds of questions in part B, legal answer writing precisely. So थोड़ा रिवाइज कर लेते हैं अब तक हमने क्या क्या पढ़ लिया है. So this is lecture number 4. This, as you can see, is lecture number 4 in the legal answer writing series of part B. Lecture number 1, 2 and 3 में, in lecture number 1 we talked about the entire essence of part B legal answer writing. We talked about why at all there is such an element in the paper wherein other law exams ke, if you see the entrances, they do not have a subjective element, and even if they do not have questions like this. We understood that what do they seek out of you in these kind of questions, what is the skill that they want to judge, that they want to evaluate out of you through your answers in this part, and how you should write your answers, which was the IRAC format. We went through IRAC, we discussed why IRAC was important, we discussed why IRAC is the most preached thing out here as well, and I believe we had only the theoretical and very beginner kind of discussion in lecture number 1. In lecture number 2, we started with the first limb of IRAC, which is I, issue formation. We talked about how do you frame issues, how issue framing is much more different than, let's say, other parts. For example, let's say why issue framing is very different and very important, because you cannot go ahead and always write emotionally charged arguments. You need to see that wherein there is the inconsistency between the law and the facts, and which of them are actually important for the final adjudication of the dispute. We talked about those things about issue framing, wherein we discussed कि कैसे issue framing तो हम generally कर लेते हैं, but solving that issue may not actually direct you to find a answer to the particular question. We discussed that thing in lecture number 2. In lecture number 3, we discussed about rule of law formation, characterization. We talked about how we do not need to memorize actually, let's say, real judgments, real papers, or like real cases for an Indian, real judges ka just entire verbatim paragraphs, each and everything. We do not remember these things for part A legal answer writing insofar that is concerned, because understand that everything that is coming to you in part A legal answer writing is a hypothetical scenario. The only thing that is given to you, the laws are perimetria, and sometimes even those things are not given. Perimetria to the laws of India, which means similar to the laws of India. So in that sense, when that is the ground you are given to play with, you need not remember the statutes, the particular rule, the particular penalty attached, but remember the overall essence of the law and how do you interpret it. in that, with that in mind, we talked about different interpretations of law. We talked about the purposive interpretation of law, as well the literal interpretation of law. We discussed these two very important limbs as well, and yes, so on and so forth. We talked why characterizing a rule of law becomes very important. Just to run through that again, run through that thing again and revise. Understand that in a hypothetical law, when something is given to you and your factual matter may not directly fit into that particular silo, you need to see why there is this law, not what is the law. Why why did the legislature came up with this law in the first place? And what do you do to check that? You see that to safeguard whom was this law made, who are the stakeholders in this law, किसको बचाने के लिए ये लॉ बनाया गया है, किससे बचाने के लिए लॉ बनाया गया है, what is the motive or intent of the law, what is if it is a commercial law, what is the commercial intent of the law, what part of the commercial transactions it is trying to safeguard, streamline, so on and so forth. Excuse me. So yes, उन सब चीजों के लिए we need to characterize our law, so that at the end of the day, when we are giving a verdict, when we are interpreting the law to our favor, we can have a benchmark कि see, this interpretation of law is better because with this interpretation what also we get, that is beneficial to the purpose of the law. This interpretation is beneficial to the purpose of the law. This interpretation is beneficial to the public interest. This interpretation is beneficial to the larger interest. All of these are the metrics by which you strengthen your arguments. So right now, today's lecture, I am here to talk about a little bit of practical things. Understand then, not all laws can be made agnostic to their specific statutes and given to you as concepts on which, like, people who haven't had engaged with law that substantively in their in their graduate studies can engage in like 250 words. I hope I'm making sense in this. Understand that कोई tax law का dispute आ गया, कि कोई वेरी नीश, तुम्हारा आर्बिट्रेशन में तो ये भी आ जाता है, वेरी नीश कमर्शियल डिस्प्यूट आ गया, उसमें यू कैन नॉट गो अहेड एंड ऑपरेट विदाउट नोइंग एनी स्टैट्यूट, बिकॉज उसमें व्हाट इज रॉन्ग एंड व्हाट इज राइट इज कंसंट्रेटेड ऑन द वेरी नंबर्स एंड क्वांटम्स. ठीक है, तो उसमें यू कैन नॉट बी एग्नोस्टिक टू द स्टैट्यूट एंड राइट साउंड आर्ग्यूमेंट्स. हाउएवर, questions relating to tort, questions relating to interpretation, questions relating to rights, restrictions, these are the things wherein even though you do not know the exact content, you do not know the precedent case laws of like constitutional law or everything, even though you do not know those things, but if you know the concepts of justice, if you know the concepts of liabilities, damages, rightful owner, these things which are very very important in your syllabus as well, if you know these things really well, then you can answer those kind of questions. So that is why essentially what kind of questions, what are the 6 permutation combination करके जो question पूछते हैं part B में, what are those questions are become very simple. They have this particular archetypes. There are only a few types of questions that are asked in an NLSAT paper, and they are only asked in repeat. So essentially, after understanding how to write an answer, you need to prepare key what are the various type of question, and for each type of question, how should you write your answer. Now, why this becomes important? Hear me out. Because generally, every type of case has its own method of argumentation. Every type of case has its own method of argumentation. Criminal law के केस में जो arguments दिए जाते हैं, वही arguments you cannot go ahead and give in the case of a constitutional law. And the facts are also very different. Understand? Let me explain this to you with the help of an example. Let me clear this page out. Eraser यही है ना? Bear with me for a second, guys. Let me explain this to you with the help of an example. Fact scenario number A. होता क्या है? This is a very overused statement that I always say. Street Hawker Act comes up. A Street Hawker Act comes up, and under the Street Hawker Act, what happens? The government bans street hawking on 10 plus important signals of the state, stating that during the high traffic, because these 10 plus signals are high traffic prone areas, there is a threat of accidents. However, street hawkers have a right to livelihood. Right to livelihood. That is curtailed herein. So the street hawker's claim is their right is unusually restricted. Yeah, their right is tyrannically restricted by the state restrictions. What side would you take up? Similarly, there is a second case that talks about something like this. Let's say that a bus driver was driving a bus from a railway fatak, railway terminal, and while he was driving the bus, generally क्या होता है, this time पे there are no rails. This time पे, the time of 4:30 p.m. से there are no trains. That's why at 4:30 but 5 p.m. से there are trains. At 4:55 he was crossing the railway fatak, and immediately, due to a sudden change in timetable, what happened, a train came in. Passengers in the third seat could see the train coming in while they were crossing the road. The bus driver also could see the train, but by the time he could see the train, he was already on the middle of the track. वो फास्ट करके जब आगे गाड़ी ले आया, गाड़ी का ये लास्ट पार्ट was hit by the train, due to which 4 people are injured. Is the bus driver negligent here? Is the bus driver negligent here? And is he liable to pay damages to these people? What is the liability of the bus driver? These are two to the in मतलब very probable questions की ये part B में last में पूछे ही गए हैं. One of this is asked. The bus driver one I believe is asked. Abdul या something करके एक bus driver था. Something like this was asked in a past paper 2023 or 2024 में. But yes, these are the kind of questions that are asked in NLSAT. You could see, essentially, they are asking you whose liability it is. But the framing of the questions is very different. Each types of these framing require उसी तरह के arguments that are tuned to these type of cases. Understood? I am not asking laws out of you. I am asking arguments out of you. Because essentially, what you guys do when you don't know how to argue in these cases, you generally go ahead to give out moral judgment of what is good or bad. So on and to the extent that people go ahead and write what the bus driver did was bad, he should have been more careful, something like this, something like that. But they don't give a benchmark. For example, in the negligency case, we given the reasonability test, the test of a reasonable man. What would a reasonable man would have done? What a reasonable man would have done in such a scenario? These tests. This is important. But instead of doing that, people just straight up write bus driver was not careful enough. If a person on the third seat could see, then he could have also seen. Bus driver should have been more careful. However, if you frame it like that, given the person in the third seat or the person on the second seat in the near about 2 meters vicinity of the bus driver could see that a train is coming, third seat person being a reasonable man in the same conditions as the bus driver was kept in, if he could see, bus driver was on an added advantage because he was driving the bus and he had better visibility. So the bus driver could see, had the opportunity to see the train, to fasten, to stop, and so that is why he's liable for his negligency, and he had a duty of care to the added thing I said, that the bus driver had a duty of care. The reasonable man could see, but the bus driver's duty was to see and check while going through a train rail that okay, that train is, if a rail is coming or not. So these are all the legal metrics that you put on to strengthen or weaken the other side's arguments. We discussed in our lecture number 1 or 2, I'm not sure, that how in cases that are put before you in Part B legal answer writing, you have to argue from both sides. Be very careful when I'm saying this. You have to argue from both sides. You have to take one side, say this is the stronger side, argue from your stronger side, take up the strongest argument from the other side, the counter argument, rebut that. But you have to argue from both sides. So to argue from both sides, you need to know the tricks that each of these sides generally play in these type of games. That is only how you can write a very enriching, a very strong, and a very convincing answer. With that said, I believe I have drove the point home that essentially there are a few archetypes of questions that are asked. Your job is to go over all those archetypes of questions and to see how and what are the general arguments that are given therein. You need to see the legal words that are put there, not the legalese, not the legal elements, the legalese that is put there in these kind of questions, because that way you will be able to better understand how do you need to plan your answer when you come across a question. Because these are the things only you get to know, you familiarize yourself with the types of questions that are asked firstly, you practice based on these type of question secondly, and you get these things reviewed from mentors. After these things, after these three stages, you practice again, keep repeating this again and again and again, you practice a lot, then you come to a stage wherein you can easily answer these type of questions. So let me run you through all the different type of questions, give you brief examples of on how these questions look like. Currently I have identified eight archetypes. Actually there are 5 or 6. A few ones I have added because if you get to know how to argue in these archetypes of questions, they may not directly be asked because they're kind of little complex, but they can be asked to you in the essay section, and you can like transpose your entire preparation from here into there. So essentially we're writing an argumentative essay only, right? So see, number one is rights versus restriction, the street hawker one that we just discussed. Different versions of it include the protest versus public order one. Protest is a right, but government's duty is to preserve public order. What should prevail, the right or the restriction? Speech versus misinformation one. People have a right to speech, people have a right to talk, but misinformation are spread across internet platforms. That's why there are internet bans. If you go ahead and see the current Delhi High Court judgment, Delhi High Court judgment in the Telegram case as well, that could be a very benchmark on how these things are applied. In terms of essay, you need to read these things side by side by section 69A, 60A of Shreya Singhal judgment, K.S. Puttaswamy, privacy, duties of intermediaries under the DPDP framework. All of these things that are covered, I believe, extensively covered last year K. In this last year during Ranbir Alabadia case के magazine में these are covered. In the people who are in the 2027 batch, I believe you have access to the last year के magazines as well. Go through them. I believe there is August to September 2025 में these things are extensively covered in the magazines. You will find them therein as well. Then second types of questions are statutory interpretations. When the meaning of a statutory word, phrase or definition is itself a dispute. Understand that इसमें जो purpose lecture number 2 में we talked about the purpose of interpretation, literal interpretation, defeating the purpose of the statute if we give it this kind of literal interpretation, all of those things. If you remember, I gave an example of a paneer thing, that government starts tax on all the on all these kind of objects, square objects, cubical objects. Government puts a tax on all the cubical objects. The purpose of the government for putting all these tax in this cubical object is not given, but essentially you could see that all the cubical objects for interstate carriage, I believe, was there. For all the objects that are carried between interstate, there is a tax on all these cubical objects. Okay. So why was this kind of thing done? You can go ahead and say that cubical objects harder to carry, harder to heavier, something like that. So generally, cubical objects are the most common way of like carrying things. Anything you could have come up with, anything you could come up with, and say that okay, there is this purpose. The government's purpose for charging a tax on cubical object might be something related to convenience, this and this. Then there was this very thing that a person who used to sell paneer in paneer cubes, upon him tax was also levied. Therein the argument was a tax can a tax be levied on paneer as well. Therein we put up like arguments that went on to discuss how number one, essentially government did this for interstate dispute objects, interstate dispute things, that interstate travel or interstate delivery things. The government did not put this thing up for paneer, which is generally a very domestic, very localized product. Number one. That is why it should not apply on this thing. The purpose, then you should break the other state's strongest argument that paneer is also sold in very cubical shapes and sizes, and these are cubical thing. Government's purpose is like to charge tax on cubical things, so this should be done. Your argument should go like something like this, that we need to understand that why taxes on cubical things are charged. Maybe because of convenience, they're easy to transport, so on and so forth. But the easiness that comes up with those cubical things that are transported like interstate, that easiness does not come with paneer. With paneer there is an added problem of spoiling, a lot of thing is wasted. So when that same amount of revenue, that same amount of benefit is not generated in the transport of paneer, then why should there be a tax and why should this tax be applied? Third thing, circumventing. Cubicle boxes में जो चीजें रहती हैं, they are kept in a cubicle structure because they can only be kept in a cubicle structure. Tomorrow, if paneer के cube size पे होने से like taxes are charged, then they can be, people can easily cut paneer into like cuboidal things or star shaped things or spherical shapes and will sell it. So if the law is also being very easily circumvented, that also means that it was not the purpose of law for this particular thing. So we talked about different arrangements, we talked about different arguments with respect to this thing. So a somewhat logical, somewhat interpretation based, somewhat legal. That's how you operate on these kind of questions. Question number 3, a contract interpretation, because a lot of times force majeure events, whether a particular event is a force majeure event or not, implied terms, if some terms are ambiguous, how do you like make sense out of these things? Remember in our first lecture we talked about why these things are asked to us, why these type of questions are asked, because they want to test our acumen कि हम कैसे सोच रहे हैं. A lot of times in like commercial contracts, a lot of terms are genuinely left very vaguely so that parties can later agree, incorporate something by reference, or they are deliberately kept like that so that those can be points, considered points of disputes in which some party has an upper hand. So it is very important for you to then understand that how that particular term can be like how that particular term can be defined, or how that particular term can be described, how that particular term can be like understood, so as that both the parties, none of them get a leverage over anyone else, both have a common ground to operate on. It is as per the international standards, so on and so forth. Then there are administrative discretion, when a public authority like exceeds the power, and the questions whether it was within their power or beyond their power. Questions as to last year I discussed a question about this puja concession happening for like 500 continuous years, but the government said that no, due to local elections it won't happen. There are a lot of arguments, but one argument, very innovative one, was as well that if a collector has the power to keep a stall on that, and if the only power that the government has through this is the puja board or something like that. So yep, arguments like this, administrative discretion. Public interest versus individual rights, this is just an evolved form of like, let's say, the rights versus restrictions thing. Within it, your things like land acquisition, forced disclosure, to what extent commercial entities have privacy, these things come up. Commercial professional regulation, again similar way. Licensing schemes, price caps, anti-competitive. Competition law is a very, I have seen in the last 3 years like 2 or 3 questions have been asked with respect to this competition law, commercial law, thoda bahut karke घुमा के basic concepts. They want innovative arguments out of you. They want to understand if you actually understand these concepts of bundling of services, like tying of services, and like anti-competitive practices, something so as to cartel, how cartels operate, so on and so forth. Then we move on towards liability and responsibility, when the question is who bears the legal cost of a loss or a wrong already caused. It is our complete tautology thing. When I teach this in the class, I'm easily going to take like 2 lectures. Vicarious liability, foreseeability, joint liability. Previously we saw about harm and so on and so forth. All of these things come here. Equality and classification, the entire affirmative action thing is more of an essay law topic, but if we discuss it herein, this will do our job as well. So, but however, in today's lecture, we'll be talking about point number 1 and point number 2 only, because point number 2 essentially we have covered in lecture number 2. Point number 1 is rights versus restrictions. We'll be seeing this, we'll be practicing a little bit of questions, and then the class will be open for discussions and deliberations. So we need to talk about, before we go about rights, why rights are restricted, we need to have a very holistic understanding about what exactly are rights. What exactly are rights? What exactly is the sovereign? And third thing that we need to understand is the sovereign a protector or a restrictor of rights? Guys, see, first of all, that you need to understand that what is a right. A right is a protected sphere of action in which the individual is free to act and from which others are presumably excluded. There are 2 aspects to a right, a positive aspect and a negative aspect. When we talk about this, putting it in Gautam Bhatia's words, it is the positive freedom and the negative freedom of things. What does this mean? Positive freedom means you have the right to do something. I have the right to practice my own religion, I have the right to do this, I have the right to do that. Negative freedom means the state will not involve itself in your matters of right. The state will not go ahead and stop you, the state will not do anything. This is the negative aspect of right. Positive aspect of right also includes the state will make you capable to do something like the de-establishment, the completely abolition of casteism, the completely of the zamindari system. These are positive rights because the state is breaking things down so that you can effectively exercise your rights. Then there are negative rights, like right to profess and practice religion. Then state comes with its prerogative of secularism, often tainted with different political ideologies. The state comes up and says that the state generally comes up and says that okay, whatever religion you want to practice, I won't be keeping an eye on you on that. That is a negative right. So it is a protected sphere. What is that? It is a protected sphere wherein you can do anything you want to do and no one else will stop you. These are both things. These are both the aspects of right. Understand this. Then there are two competing theories of rights. If a few people would have done the ये in like BA, liberal arts, anything, let's say sociology हो गया या फिर political science हो गया, you guys will be very accustomed with the Hart, Kelvin, Hart, Fuller, all of these kinds of debates. They talk about conceptions of laws. A very pretext, a very prelude to these essential debates are understanding the nature of right, law, and sovereign. A lot of people, so the discussion as to this begins from the question that whether rights pre-exist the sovereign or rights are something that come into that are effectuated only after a sovereign comes into effect, which means that is there any right without a centralized authority to enforce those rights? India, let's say there was no nation, two of us people are like in some kind of forest and I killed one person. Have I violated any right, given that there is no ruler, no kingdom, no democratically elected like institution above us to punish us? And if is that only when they are within the jurisdiction of an institution, jurisdiction is for democratic or autocratic, monarchic, archaic, any kind of institution, तभी अगर उसके jurisdiction में हूँ, territorial jurisdiction है, any kind of jurisdiction में हूँ, तभी अगर मैं किसी को मारूँ तो उसका right violate हो रहा है. So the question was that only, are rights only a thing when there are like let's say these things, when there is a sovereign to manage them, to enforce them? Are there no absolute rights, rights that predate the sovereign, that pre-exist the sovereign? These are the debates that led to the creation of a different kinds of right, a different like gradient of right, different gradient of right. You have your fundamental rights to which no derogation is allowed. You have your statutory rights, which are granted to you by the sovereign. Statutory rights are given to you by the sovereign and can be taken from you by the sovereign as well. Let's say your right to vote. Your right to vote is given to you by the sovereign. Voting is not a fundamental right. Fundamental right, sovereign cannot take away from you, but it can put restrictions. Why does the sovereign put restrictions of right becomes our next topic of discussion. Why does the state restrict rights? Because your right can collide with another person's right. Your right can collide with the collective interest of the society, which are public order, health, security, so on and so forth. And the unrestricted rights are self-defeating. Total free speech can silence others because we are not equal. The capabilities approached by Amartya Sen, we are not equal. A few groups in the society are stronger, a few are weaker. That is why हर कोई equal नहीं है. So अगर हर किसी के पास absolute unrestricted right to speech है, जो तो stronger होगा वो तो ज्यादा बोलेगा ना, जो weaker होगा तो वो तो बोल ही नहीं पाएगा. First thing. Secondly, total privacy can shield wrongdoing. प्राइवेसी है, किसी को मारा तुमने, मैं नहीं बताऊंगा, मेरी प्राइवेसी है. That is why the sovereign has to balance these rights. The sovereign enforces these rights as well as restricts these rights as well, and that is the job of the sovereign. So rights are rarely absolute. The question is never whether a right can be restricted. Understand, NLSAT में पूछा नहीं जाता कि क्वेश्चन ये है कि can a right be restricted. Although a lot of people interpret it like that, can a right be restricted, get emotional that no, a right should not be restricted. In case of Nanda Bharati, this was that. No guys, don't do that. Be very to the point, very specific, niche specific, pinpoint answer likho. The question is whether particular restriction is justified. And how do you say whether a restriction is justified or not? Do you guys know any metrics? If not, come. There अच्छा ओके, तो मुझे यहाँ पे समझाना था, मैंने बात कैसे गंदा कर दिया. ठीक है. The first filter is reasonableness and second is proportionality. If a restriction put by the state is reasonable, proportional, like has a reasonable rational nexus, okay, इसके वो तो इसके अंदर ही आ जाएगा. There are no less restrictive means. Like the decision was taken was not arbitrary. Like if the object was legitimate. These are all whatever we discussed herein as justifiable grounds for a restriction. See, first we'll talk about reasonableness, second we'll talk about proportionality. Uske baad we have a few case studies. Then we can go on to the question. See reasonableness, how it operates. It is the first filter. A restriction on a right is reasonable when it can survive three basic questions. What are the questions? Is the objective legitimate? Is the state actually pursuing a reasonable public goal? एक पब्लिक गोल को परस्यू कर रहा है या फिर बस इनकन्वीनियंस साइलेंस कर रहा है? यू नीड टू आस्क दैट. Is the objective legitimate behind a particular type of restriction? Had been the case street hawking को अगर बस इसीलिए बंद कर रहे हैं so that state can sell contracts, because sell contracts of street hawking to commercial players, that would not be a very good restriction. That would not, मतलब अच्छा restriction तो बिल्कुल नहीं होगा वो, because violation of a right cannot be balanced against the objective of commercial benefit. No matter how that commercial benefit is against tied to public safety, public good, public development, that cannot be tied back to that end that strongly. And then you have to argue that how restriction does not have a legitimate object but rather an illegitimate object, malafide means, dirty hands the state has, all of these terms you can use. Second, is the restriction arbitrary? Is the restriction arbitrary? You need to focus on this aspect as well. Has the state acted with reasons and evidence, or has it picked targets? Yeah. Hey guys, continuing with the lecture. So, is the restriction arbitrary? State action cannot be arbitrary. A state should always have proper reasons to justify its actions. Let us go back to the street hawker question that we had. Street hawker question mein, you can ask whether the state had any like empirical evidence to show that जो accidents हो रहे हैं, it is due to the presence of street hawkers. Was there any past incident that an accident happened because of street hawking? Anything. If the states do not have a rhyme and reason, please use these terms like rhyme and reason अगर state के पास नहीं है, then the action becomes arbitrary. And when something is arbitrary, that cannot be used to restrict a fundamental right. Fundamental right. Okay, one thing that you need to, okay, next class I'll also bring that. One thing that you need to do is understand the fundamentals right that we have, the list of fundamental rights with examples how they operate, so that you are much more familiar with, okay, इस वाली चीज में ये वाला fundamental right आएगा. With street talking, I could come up easily with the right to livelihood. Then there are other things as well. Right to sleep is a fundamental right as well. Ramlila Maidan case. So look into those things, you will be able to understand. Just keep a like a list ready. You can take the help of AI, I don't mind, but just be familiarized with all the kinds of fundamental rights, because essentially they're restricted to a few, but interpretation ke through, judicial innovation ke through, they have, the list has been extended. So keep that in mind and do that. Next thing, is there a rational connection? Does the means chosen actually advance the stated objective? Okay, the same thing, is there a rational nexus, which is objective meet हो रहा है या नहीं? ठीक है, objective meet हो रहा है नहीं. For that you need to show how that's the same thing, arbitrary जैसा ही, कि whether the objective and the again the restriction that is happening has any rational nexus, or are they very polarly very distinct in their operation. Then is there proportionality? In that slide we talked about reasonability, proportionality, so on and so forth. The same things you have to ask. Number one, is there a legitimate object? Number two, is there a rational connection? The three and four of proportionality become very important, because they ask, wasn't there any other less restrictive means? Couldn't you have like come up with any less restrictive means so that your purpose would also have been met and the right would also have been restricted to a lesser extent? That is this question. Then is the question of balancing. Okay, was there no mean in which the restriction can be decreased as well, and while the purpose of the state is met as well? So balancing both the things is something that comes in your conclusion rather than in your arguments. एग्जाम्पल देखो, स्कूल में पीनट एलर्जी थी कुछ बच्चों को, पूरे स्कूल में पीनट बैन हो गया, तो रैशनल कनेक्शन है. क्वेश्चन ये पूछा जाएगा कि पीनट बैन करने से पीनट एलर्जी वाले बच्चों को बचाया जा सकता है नहीं. हाँ बचा जा सकता है, नहीं नहीं बचा जा सकता। एक और क्वेश्चन पूछो कि लेस रिस्ट्रिक्टिव मीन कुछ नहीं है क्या? एक पीनट फ्री टेबल लंच टाइम में, ऐसे टेबल्स जहाँ पे पीनट्स नहीं, पीनट्स वाले लंच डब्बे वाले बच्चे जाके नहीं बैठ सकते, could not that have done the job as well? Less restrictive means then balancing का thing, फाइंडिंग आउट अ वे इन विच जो बच्चों को पीनट पसंद है उनका राइट भी मेंटेन हो जाए, जो बच्चों को एलर्जी है उनके लिए वो बच भी जाए, मिनिमम रिस्ट्रिक्शन, बेटर गाइडेड वे, एवरीथिंग एसेंशियली इज a negotiation. How do you negotiate between the interest of the both the parties in a legitimate manner? दूसरे का अगर इंटरेस्ट ही है कि मैं मार को किसी को मुझे बचना है, illegitimate illegal interest, so then that cannot be negotiated. First test is that therefore the legitimate objective test. Once that is met, you can come to these things. The case studies, like for example right versus restriction का, three things are generally asked to you. The internet shutdown, गवर्नमेंट सेल्स की सिक्योरिटी बन जाती है लोगों की, लोग बोलते हैं हमारी लिबर्टी चली जाती है, ठीक है, बिकॉज इंटरनेट टुडे बहुत से लोगों का लिव लर्न एंड अर्न का भी प्लेटफॉर्म है, LLE, लिव लर्न एंड अर्न का प्लेटफॉर्म भी है इंटरनेट. दैट्स व्हाई दैट्स वन थिंग. द आधार रो, कंप्लीट पुट्टास्वामी रो एंड एवरीथिंग. Public welfare versus public privacy, which one is more important? Both of these are rights. You need to balance which right is more important, because to like strengthen one right you have to like weaken another right. So how do you do that? Creative solutions are needed. Public protests, get it, protest is a right, but again assembly public disorder hone se kya hoga, that is another thing. So notice the methodology, not the outcome. So kaise, how do you implement these tests of reasonability and proportionality in your answers becomes very very important. These tests can be used from each of the sides, both sides you can use these tests. How you test is important. Internet shutdown wale case mein please look at the recent Delhi High Court judgment in the Telegram ban case, by the way. Then is our second type of question, guys, I believe. This I'll be taking comparatively less time on because we have like discussed it extensively in our lecture number 2. So statute itself is the battlefield, the statute itself is dubious. How do you go ahead and how do you characterize the statute becomes very very important for you guys. Statutory interpretations पार्ट भी बहुत बार आते हैं, जिस जहाँ पे क्वेश्चन को तुमको बोला जाता है कि यू हैव टू सी हाउ डू यू इंटरप्रेट अ स्टैट्यूट. व्हाई इज इट सो? बिकॉज नंबर वन दैट, पहली बात, like transposition of statute. Understand the background of it as well, SIA में काम आएगा. A lot of times UK, Sweden, इन सब के laws को लाके इंडिया में रख दिया जाता है, wherein the overall commercial structure do not match, wherein the people's tendencies do not match, the consumer behavior of the general populace का behavior, the kind of defaults that people do not match. So that is why there is no good transposition of statute, doesn't work out. Examiner, okay, here in analytical, when there is no good statute, ये पहले लाना होगा मुझे. So you need to be analytical while saying that your job is not whether something fits within the black and white of the short text that is given in the question. Your job is to question the entire text as well. ये law है, hypothetical law. Law के हिसाब से fact हुआ है नहीं, ये मत देखो. You can see that if you want a strict interpretation, textual interpretation, you can do that. But generally your tendency, or generally your trick should be to go ahead and like ask this question कि law नहीं, ये के हिसाब से, practicality के हिसाब से, you need to check that whether like the statute is good at all, whether it meets the public interest or not. Rule of law वाली बातें कि characterize who are the stakeholders, what is the purpose, so on and so forth. So everything has two readings. One is like purposive, one is like textual. You have to choose between what. Literal and purposive reading, I'll just brush over these things in a go. The strength of literal reading is statute becomes predictable. The very important thing is, why do we literally read the statute, whatever is written therein? Because understand the endeavor of law, the purpose of this endeavor of law is to make people's life easier. If people know that there are consistent laws that are not the whims and fancies of judges, then those are easy to follow. If the law keeps changing with every particular judgment, particular facts, it becomes very unpredictable for people to how do they actually go ahead and dictate their lives, at what extent do they actually cross the lines with the law and implicate any kind of liability upon them. So these things become very very dubious, very very confusing for people. That is why that is a strength of literal interpretation. Weakness again, a single line cannot suit all the different stratas of society, all the varied myriads of cases that come, and if it becomes very mechanical, it does not lead to an effectual and justified dispute resolution, right resolution. Purpose की strength वही है, Pervasive, one very important strength that it adapts the laws to the new technology, to the growing needs of the society. Weakness is judges effectively rewrite the statute, law is no longer predictable. The framework I have like today focused on tech law disputes with the point that purposive interpretation benefit tech law cases because tech law के जो existing laws हैं those are kind of old and archaic, coming somewhere in 1990s to 2000s, are currently with the onset of so many technologies, cloud computing, web 3, web 4, AI, so on and so forth. Those things cannot work that well, so how do you innovate them is the question. The four step framework. See, what do the words say, what was the problem, then the parliament trying to trying to fix, and currently what the problem is. इसमें AI रेगुलेशन, डिजिटल मार्केट प्लेसेस, प्लेटफॉर्म लाइबिलिटी, सोशल मीडिया, इन सब चीजों में क्वेश्चन आ जाएगा, जिसके क्वेश्चन हमने लेक्चर नंबर 2 में कर भी रखे हैं. This becomes a very important question. This question I'll be solving, and this question will be for you guys as homework. You'll do this as a homework, and I will be solving this question. ठीक है. क्वेश्चन क्या है? मिनिस्ट्री ऑफ इंटरनल अफेयर्स बाय अ रिटन नोटिस 1000 से ज़्यादा यूजर हो, प्लीज डिस्क्लोज द डाटा, कॉन्ट्रैक्ट मेटा डाटा contributing to disorder, no prior judicial. ठीक है. We know the essential case. It is the same thing. To generally surveillance versus privacy होता है, जैसे surveillance, privacy, protest, तीनों चीजें मिला के जो rights versus restriction का ये अच्छा very mixed question this is. So you can see at what ends to the fault line exist for each of the things. At what end the law actually takes over. At what end the administrative lacunas, the administrative malfeasance is noted. So if you want to argue herein, the same limbs you need to keep. The issues, what are the issues you can frame? I have listed down all the issues that can be framed. If you want to argue from the side of the state, you will frame a particular type of issues. If you want to argue from the side of iris vora and the entire vora and by the both of these things, you will frame a particular set of issues. So see how those can be framed. Number one issue can be framed is the state's objective. The public order is a legitimate objective or not. If you are framing from the perspective of the state, this becomes very important. Becomes तुम बताओगे कि state का objective तो legitimate है, तो why cannot state put restrictions? Second is section 7 power exercised arbitrarily? Arbitrariness, पूछोगे कि without reason. Arbitrary मतलब without reason किया गया है. No state has given proper notice and so on and so forth. Is there a rational nexus between disclosure and the stated objective? This is the type of question that you may ask from the side of this protesters. What was there any less reasonable opportunity or not? Again, protesters particular issue. Burden of privacy, speech, assembly, kuch actual gain hota hai isse. So questions like this, issues like this can be framed. Make sure that you do not frame more than two issues, three on a very day, because okay, understand that okay बहुत ही dense question और third issue में छोटा discussion होगा, तो you can frame, but generally don't frame more than two issues. Side A, from this side you can stay. That memo jo tha, that shows that the entire thing, such as the thing of arrest, was planned beforehand. There is no rational nexus between contacts and drafts के ये होने का, disclosure का, कि कैसे वो ये होते हैं related. Less restricted options are present. Gives a few example. Narrowly name karo suspect scope, proper pinpoint karo instead of a blanket ban. And chilling effect. Whenever you are going against the state, bring the argument of chilling effect, that if you do this today, tomorrow the actions of the state will be even much more archaic. ठीक है. From the side of the state, go within very standardized arguments that state had legitimate objective, there were inbuilt safeguards, 14-day tribunal date, pre-authorization, सब चीज, सॉरी 14-day ट्राइब्यूनल डे चेक है, प्री ऑथराइजेशन जुडिशियल अथॉरिटी से हो, तो अर्जेंसी जो होती है, ऑपरेशनल अर्जेंसी इन टाइम्स ऑफ दिस सेंसिटिव प्रोटेस्ट, वो चली जाएगी. रेशनल कनेक्शन है ऑब्वियसली. डिजिटल कोऑर्डिनेशन, आज के दिन डिस्क्लोजर ऑफ दीज डिजिटल रिकॉर्ड्स बिकम वेरी इंपॉर्टेंट. बिकॉज वाई बिकॉज understand that both of the things, all of the protests are organized via this entire internet का network only, social media platforms only. तो वहाँ पे कैसी क्या communication हुई है, क्या सब directions दिए गए हैं, that become important. And the memo is just a collateral. Wherever this strategy we talked in lecture number 3 also, I believe, wherever there is a weak counter argument against you, मतलब strong counter arguments against you that can weaken you up, bring that counter argument, accept it. But how do you deal with it? You say okay, I accept that this exists against me, but this is a collateral, because what point I'm trying to make does not relate to this, it will like subsist. यहाँ पे जैसे बात की कि procedural irregularity, ठीक है, ठीक है, procedural irregularity extensively बात की गई, तो लोगों का जो ये है, this protest is sensitive and all the other those tests are met. So nonetheless, even if this memo was made pre to this entire thing, does not matter. Nonetheless, this thing comes under the ambit of like restriction, and it will be restricted. So yes guys, those are all the kinds of questions. Take a screenshot of this, answer me. For the people who are on YouTube, you can take a screenshot of this, answer this, send your answer on YouTube, on our DMs of all social handles, X, Instagram, Facebook, Telegram तो कुछ दिन में आ जाएगा. So DM us there and we will be checking it therein as well. Or like yeah, then this is those का answer क्यों दिखा दिया. So essentially, what do we learned in this? That identify the archetype, argument, go ahead, proceed with your arguments based on that. Frameworks, you need to learn about these frameworks of how, what kind of arguments need to be put forth. And both sides ka reasoning you need to show. But however, you need to always pick a side. With that said guys, this was our lecture. आगे के lecture की series का roadmap ये है. Keep a note of that. With this, we end our YouTube के people के लिए the lecture herein. For people in the batch, come up with your doubts, list them in the chat box. We'll take them over one after the another. And with that said guys, as I always say, take care of yourself and aim to be.
Are you preparing for 3-year LLB entrance exams but feeling overwhelmed and unsure where to start? Do you struggle with finding the right resources, guidance and clarity, all in one place? Tired of institutions selling just mock tests or rebranding old materials meant for other exams and charging a fortune for it? Introducing Lawfren, your one-stop solution for 3-year LLB entrance exams. Lawfren brings you cutting-edge tools to supercharge your preparation. With our exams portal, you can participate in live All India tests and instantly see your rank, giving you real-time insights into your performance. Practice questions on individual topics, sharpen your skills, and get exam ready with confidence. Lawfren, aim to be.